What if I told you that the very idea of a contract, something we associate with fine print and digital signatures, today once determined whether you lived in freedom or servitude, whether you could marry the person you loved, or even whether your family would eat next season? Long before courtrooms and lawyers, before empires rose and fell, human beings were already crafting intricate systems of agreement, etching their promises into clay and stone with a permanence that would outlast kingdoms. These ancient contracts were far more than simple deals. They were the foundational architecture of society itself, the invisible framework that allowed civilizations to grow beyond tiny villages into complex networks of millions. Think about that for a moment: your identity, your duties, your place in the world, all defined by marks made on a tablet under the sun thousands of years ago. We often imagine the distant past as a lawless time, governed by brute strength or tribal custom, but nothing could be further from the truth. From the Fertile Crescent of Mesopotamia to the banks of the Nile, and from the Indus Valley to the early city-states of the Mediterranean, written agreements formed the backbone of daily life. They regulated everything: your marriage, your debts, your property, your labor, even your relationship with the gods and the king. These documents wove together the economic, social, and spiritual fabric of communities, creating a web of mutual obligation that enabled trust between strangers and stability across generations. They were humanity's first great experiment in building order out of chaos, and in many ways they succeeded beyond anyone's wildest dreams. In this video, we're going to journey back to the very dawn of legal systems, to a time when law was being invented stroke by stroke on damp clay. We'll explore how these early contracts didn't just reflect society, they actively shaped it, reinforcing power structures, enabling vast trade networks, and sometimes trapping people in cycles of exploitation that resonate uncomfortably with modern issues. You'll see how something as simple as a loan agreement could alter the course of a family for generations, and how temples and palaces became the first repositories of human rights and responsibilities. This is a story about how we learn to promise, to trust, and to hold one another accountable, a story written in stone and baked hard by time, waiting for us to decipher its lessons today. But before the first contract could be etched into clay, something even more fundamental had to exist: the very concept of law itself. Think about that transition for a moment, from a world governed by the spoken word, by traditions passed down through generations and the sometimes arbitrary judgments of elders, to a world where rules were fixed, visible, and applicable to everyone. This monumental shift began in the fertile river valleys of Mesopotamia around 2,100 years before the Common Era. It was here that we find the earliest known example of a formal legal code, the Code of Ur-Nammu, created under the rule of a Sumerian king. This wasn't merely a list of punishments, it was a visionary attempt to build a predictable and orderly society. For the first time, obligations between people weren't just implied by custom, they were explicitly stated. Disputes over property, injuries, or family matters could be settled by referring to a public standard, reducing the need for blood feuds or violent retribution. This created a framework of stability that allowed communities to expand, fostering trust between people who weren't bound by blood or tribe. As scholar Martha Roth has highlighted, these ancient codes served a dual purpose. Yes, they were tools for social control, but they were also intricate systems of economic regulation. They meticulously outlined how harvests should be divided, how debts should be handled, and how inheritances should be distributed. This predictability was the lifeblood of a growing civilization. It meant a farmer could plant his fields with some assurance he would reap the benefits, or a merchant could extend credit knowing the terms were enforceable. This revolutionary leap from oral tradition to written code didn't just change how justice was served. It fundamentally altered the relationship between the individual, the community, and the state, setting the stage for every legal system that would follow. But how did they actually do it without paper, without computers? How did they create records that would last for thousands of years? The answer lies in one of humanity's most ingenious and durable inventions, the clay tablet. Imagine a scribe in ancient Mesopotamia sitting with a lump of wet river clay. He would knead it carefully to remove air bubbles, then shape it into a flat, palm-sized rectangle. His tools were simple: a sharpened reed stylus with a triangular tip. Pressing this stylus into the soft clay, he wouldn't write in the way we think of it. He would create a series of wedge-shaped impressions, a script we now call cuneiform, from the Latin word for wedge. This was a slow, deliberate process. Each mark had to be made with precision before the clay began to dry. A single contract tablet would list the names of every party involved, the specific goods or services being exchanged, the agreed-upon price or terms, and perhaps most importantly, the names of the witnesses. Once the terms were fully inscribed, the parties and witnesses would roll their personal cylinder seals across the clay. These small, carved stone cylinders were unique to each individual, acting as a signature and a safeguard against forgery. The final step was preservation. Some tablets were simply left in the sun to dry hard, while for truly important documents, they were baked in a kiln, transforming the soft clay into a ceramic record that was virtually indestructible. This is why we have so many of them today, surviving fires, wars, and millennia buried in the earth. This technology was nothing short of revolutionary. As historian Dominique Charpin so aptly puts it, the act of writing the contract made an abstract promise into a tangible object. An oral agreement lived only in memory, subject to change, dispute, and fading recall. But a written contract was fixed. It was a thing that could be held, stored, retrieved, and presented as undeniable proof. This tangibility allowed for a whole new level of economic and social complexity. A merchant in Ur could now enter into an agreement with a trader in a distant city, both confident that the terms were unchangeable. A king could issue a land grant knowing the record of ownership would outlive him. This wasn't just about record keeping. It was about creating a framework of trust that could span vast distances and long periods of time, enabling laws and commerce to scale in ways that were previously unimaginable. The humble clay tablet was in many ways the engine of early civilization. Now consider where all those clay tablets were stored and who gave them their power. You couldn't just seal an agreement in your own home and expect everyone to respect it. For a contract to truly bind people across a city or even a kingdom, it needed the backing of an authority that everyone feared and respected. In the ancient world, that authority wasn't found in a courthouse or a government office. It was housed within the towering, awe-inspiring structures of temples and palaces. These were far more than just places of worship or royal residence. They functioned as the central hubs of all legal and economic activity. They were the banks, the courthouses, and the public record offices of their time, all rolled into one. The priests and the rulers didn't just oversee spiritual and political matters. They acted as notaries public, as judges, and as the ultimate enforcers of the law. They employed armies of scribes who meticulously filed away thousands of contracts in vast, organized archives. These collections of tablets were essentially the earliest databases, a permanent and searchable record of who owed what to whom, who owned which piece of land, and what promises had been made under oath. Take, for instance, the incredible temple records unearthed at the ancient city of Ur. These tablets reveal an astonishingly detailed and bureaucratic world. There were contracts for loans of silver or grain with specific interest rates and repayment dates. There were leases for temple-owned farmland, specifying exactly what portion of the harvest the farmer owed as rent. There were even formal adoption contracts where a childless couple could legally adopt an heir, complete with clauses to protect the child's inheritance rights. Every single one of these agreements was drafted, witnessed, and stored by temple scribes. This was a brilliant system of control. By centralizing the legal process, the temples and palaces didn't just facilitate commerce, they guaranteed it. Their immense authority, both earthly and divine, lent an unshakable weight to every contract that passed through their halls. To break an agreement wasn't merely a breach of trust with another person. It was an act of defiance against the king's law and an offense against the gods themselves. This created a powerful deterrent, a system upheld by a potent combination of fear of royal punishment, faith in divine retribution, and the very real force of the state's enforcers. It ensured order and predictability, but it also meant that the institutions holding the power also wrote the rules, often to their own immense benefit. Yet for all the meticulous record-keeping and legal formalities, it's crucial to understand the crushing human reality behind these contracts. Imagine a farmer, his fields parched by a drought that wasn't his fault. His family is starving, his seed grain is gone. His only option is to approach a wealthy landowner or a temple official for a loan. The terms are steep, the interest is high, and the only collateral he has to offer is his own body, his wife's labor, or his children's future. He presses his seal into the clay, not as a free man making a deal, but as a desperate one signing away his liberty. This was the brutal essence of debt bondage. The contracts themselves were chillingly specific. They didn't just say a person would work off a debt. They detailed the exact quantity of bread and beer they would receive as rations, often just enough for basic survival. They listed the specific tasks: harvesting barley, weaving textiles, milling grain. Some even stipulated that the debtor could not work for anyone else until the obligation was fulfilled, effectively creating a closed loop of servitude. And perhaps most heartbreakingly, many contracts included clauses where the borrower pledged not only themselves but their entire household, binding their family for generations. A father's debt could become a son's inheritance, a burden of servitude passed down like a cursed heirloom. Recognizing the potential for horrific abuse and social unrest, rulers did attempt to impose limits. The most famous example comes from Hammurabi's Code, which in Law 117 explicitly states that if a debtor offers his wife, his son, or his daughter as security for a loan, they shall work in the house of their creditor for 3 years, and in the 4th year they shall be set free. On the surface, this seems like a progressive, even compassionate piece of legislation. It acknowledged the problem and tried to solve it with a time limit. But the grim archaeological evidence suggests the reality on the ground was far different. For one, the law only applied to free citizens, not the vast population of slaves who had no protections at all. Furthermore, a crafty creditor could easily find ways around the spirit of the law. They could simply draw up a new contract at the end of the 3 years, or claim that the original debt had not been fully paid due to accrued interest or the cost of those meager rations. In many cases, the release was conditional on the original loan amount being repaid in full, an impossibility for someone who had spent years in servitude with no means to earn outside income. So while the law existed on stone steels for all to see, the power dynamics on the ground often rendered it meaningless. The creditor held all the cards, the food, the shelter, the legal documents, and the debtor had little to no recourse. This created a self-perpetuating underclass, a cycle of poverty and dependence that was nearly impossible to break. The contract, that tool of order and trust, became in these instances a weapon, a legally enforced chain that locked people into a life of forced labor, all under the solemn, unassailable authority of the written word and the seal. While the world of commerce and debt was governed by stark ledgers of profit and loss, the ancient legal systems reached even further, into the very heart of the home and the most intimate human bonds. It's a jarring thought for us today, but in societies like Sumer and Egypt, love and affection were often secondary considerations in marriage. The primary framework was legal and economic. A marriage was not merely a ceremony or a social custom. It was a binding contract, a meticulously negotiated agreement between two families, and its terms were recorded with the same solemn precision as a deed for a parcel of land or a loan of barley. These documents were the blueprints for a new household, and they laid out the financial architecture of the union with stunning clarity. The bride's family would typically provide a dowry, which could include anything from household goods and livestock to parcels of land or precious metals. This wasn't a simple gift. It was the woman's personal contribution to the marital estate, and its management was a serious legal matter. In return, the groom's family was often expected to present a bride price, a payment to the bride's father that formally sealed the alliance and compensated him for the loss of a productive member of his household. This exchange of wealth transformed a personal relationship into a public, economic fact, recognized and enforceable by the community's legal authorities. Crucially, these contracts weren't solely designed to benefit the patriarchs. They also offered women a degree of legal protection that was remarkably advanced for its time, creating a safety net within a patriarchal system. A standard marriage contract from ancient Mesopotamia would explicitly guarantee the wife a set annual allowance of food, oil, and wool for clothing from her husband's resources. This ensured her basic economic security was a legal right, not a charitable gift. Furthermore, the dowry she brought into the marriage remained her property. While her husband had the right to manage and use it, he could not legally sell it or squander it without her consent. In the event of a divorce initiated by the husband, he was almost always obligated to return the full dowry to her, allowing her some financial independence as she returned to her father's house. Some contracts went even further, stipulating specific penalties for a husband's neglect or abuse. For instance, a clause might state that if the husband took a second wife without the first wife's permission, he would be required to pay her a significant sum of silver and grant her a divorce on the spot if she demanded it. These provisions show a sophisticated understanding of the vulnerabilities women faced and an attempt, however imperfect, to use the law to mitigate them. Of course, this legalistic approach also had a darker side, reinforcing the idea of women as economic assets to be transferred between households. The penalties for a wife's infidelity, for example, were typically far more severe than those for a husband's. A contract might state that an unfaithful wife could be drowned or thrown from a cliff, while a wandering husband might simply face a financial fine payable to his wife's family. Primary concern was the legitimacy of heirs and the clear transmission of property, not emotional fidelity. Divorce, while possible for women under certain conditions, was much more difficult for them to obtain. A woman usually had to prove severe neglect or abuse to have her petition accepted by the authorities, whereas a man could often divorce his wife for far lesser offenses, or even for simply failing to bear him children. This double standard was baked directly into the contractual language, a stark reminder that these documents were products of their time, designed to uphold a social order where lineage and property were paramount. The long-term implications of this system were profound, shaping family structures for millennia. By legally defining the roles of husband and wife, the rights of children, and the rules of inheritance, these contracts created a stable, predictable framework for society's most basic unit. They ensured that wealth remained within recognized family lines and that children's legitimacy was beyond dispute, which was essential for maintaining social order. The very concept of a prenuptial agreement, which we think of as a modern invention, has its roots in these ancient clay tablets. They transformed the chaotic and emotional realm of family life into something that could be managed, adjudicated, and controlled by the state. This was the ultimate penetration of law into private life, proving that for the ancients, no aspect of human existence was too personal to be left outside the bounds of a contract. But while marriage contracts defined the family unit, it was the earth beneath their feet that truly anchored ancient lives. In a world built on agriculture, land wasn't just an asset. It was the very source of survival, identity, and status. The ability to definitively prove who owned which plot of earth, who had the right to farm it, and who could pass it on to their children was nothing short of revolutionary. This is where property contracts truly came into their own, transforming the landscape from a patchwork of contested claims into a mapped and managed grid of legal ownership. The contracts unearthed from ancient cities like Nippur and Lhasa are stunning in their detail and complexity. They go far beyond a simple statement of sale. A typical land contract would describe the property with the precision of a modern surveyor. It might specify that the field was located to the north of the canal of the god Shamash and to the east of the property of Sin-Idunum. It would list its exact size in standard measures, often using units based on the amount of land a pair of oxen could plow in a single day. Crucially, these documents named all adjacent landowners, effectively creating a permanent record of boundaries to prevent future arguments. To make these boundaries physically clear, fields were marked with stone pillars or inscribed boundary stones called Juris, which served as an immutable, on-the-ground reference point backed by the legal authority of the contract stored in the temple archive. This meticulous system of documentation did more than just prevent neighborly squabbles. It unlocked economic potential on a massive scale. For the first time, a farmer could feel secure in making long-term investments in his land. He could spend a season building an irrigation ditch or plant an orchard of date palms that would take years to mature, knowing that his claim to the land and the fruits of his labor was legally guaranteed and could not be arbitrarily taken from him. This security fostered innovation and increased productivity, which in turn supported growing urban populations. Furthermore, these clear titles made land a liquid asset. It could be confidently bought, sold, leased, or used as collateral for loans. We have records of elaborate lease agreements where a landowner would rent out his field to a tenant farmer in exchange for a share of the harvest, typically 1/3 or 1/2. These contracts specified everything from the type of seed to be used to the division of the crop, ensuring both parties knew exactly what was expected. This created a flexible agricultural economy where land could be worked by the most capable hands, not just its original owner. Of course, this system also had another, equally important beneficiary, the state. For any ruler, knowing who owned what and where was the foundation of taxation. Detailed property records allowed royal officials to accurately assess the agricultural dues owed to the palace or the temple. A larger, more productive field meant a larger tax obligation, and the contract was the proof that settled any dispute over the amount. This bureaucratic efficiency was the lifeblood of the ancient state, funding public works, the military, and the immense religious institutions. It also provided a mechanism for the king to reward loyal servants by granting them tracts of land, with the contract serving as an irrevocable proof of the royal gift. This interplay between private ownership and state interest is a dynamic that continues to this day. The concept that you could truly own a piece of the earth, that this ownership could be legally defended against powerful neighbors or even the crown itself, and that this right could be passed down to your heirs, was a profound development. It created a stable class of landholders with a vested interest in the long-term stability and prosperity of the community. This ancient framework of titles, surveys, and deeds is the direct, albeit much evolved, ancestor of our modern systems of real estate law, proving that the urge to mark our place on the earth and have that mark recognized by others is a fundamental pillar of civilization itself. While families were being formed and farmland was being measured out back home, a different kind of contract was fueling adventures that stretched to the very edges of the known world. Picture a bustling Assyrian trading outpost in central Anatolia nearly 4,000 years ago. A merchant far from his homeland finalizes a deal with a local metal supplier. They don't share a language, a culture, or a god they pray to. The only thing that allows this transaction to happen is a lump of clay, carefully inscribed with wedges that spell out a promise both understand. This was the power of the ancient commercial contract. It wasn't just a receipt, it was a passport that allowed trust to travel across deserts, mountains, and seas, connecting disparate cultures into a single, sprawling economic network long before the word globalization was ever conceived. The complexity of these agreements is staggering. A typical trade contract was a masterpiece of logistical planning and risk management. It had to account for immense distances and the passage of many months, sometimes years. The document would meticulously list the type, quality, and exact quantity of goods: so many minas of tin, so many bolts of fine linen, so many jars of olive oil. It fixed the price not just in one currency but often specifying the equivalent value in a local medium of exchange, whether it was silver shekels, copper ingots, or even bags of grain. Crucially, it included a delivery date calculated based on the expected travel time of a caravan or the sailing season of a ship, but the ancients were realists. They knew the world was a dangerous place, and so their contracts included what we would now call force majeure clauses. If a ship sank in a storm or a caravan was wiped out by bandits, the merchant was not held liable for the lost goods. The loss was absorbed by the investors as a cost of doing business. However, if the merchandise was lost due to the merchant's negligence, if he took a foolish shortcut or failed to hire adequate guards, he would be personally responsible for repaying the entire value. This careful allocation of risk was the bedrock of long-distance commerce. Perhaps the most revolutionary business model to emerge from this era was the Commenda partnership, a concept so powerful it's still used in venture capital today. Assyrian tablets provide exquisite detail on these arrangements. A typical contract would involve a wealthy investor, often staying safely in the capital city, providing the capital to fund a trading expedition. The traveling merchant, who provided his expertise and labor but little to no money, would take the goods on a long journey to a foreign market. Upon his return, the profits were divided according to a pre-agreed ratio, usually giving the investor a larger share of the return to compensate for his greater financial risk, while the merchant was rewarded for his arduous and dangerous work. This system was brilliantly efficient. It allowed capital to flow from those who had it to those with the skill and courage to use it productively, dramatically expanding the scale and scope of trade. One tablet might record an investor providing 20 pounds of silver to a merchant heading to the Levant, with the agreement that upon the safe sale of the goods and return home, the investor would receive 2/3 of the profit while the merchant kept 1/3. This wasn't just a business deal, it was a leap of faith codified in clay, enabling economic ambition on a previously unimaginable scale. the impact of this contractual framework rippled far beyond the economic sphere. These trade routes, secured by legal agreements, became the arteries through which civilization itself flowed. Along with spices, textiles, and metals, merchants carried ideas, technologies, religious beliefs, and artistic styles. The alphabet developed by Phoenician traders, essential for their commercial records, was adopted and adapted by the Greeks. Mesopotamian legal concepts traveled along the Silk Road, influencing commercial practices in distant lands. A contract for Egyptian papyrus might indirectly lead to the spread of new architectural techniques or medical knowledge when the merchants gathered in foreign ports and shared stories. The contract, in its dry, precise language, was silently building cultural bridges. It created a shared language of commerce, a universal understanding of promise, obligation, and consequence that allowed a Babylonian, an Egyptian, and an Indus Valley trader to find common ground. This proto-international law smoothed over cultural differences and created islands of predictability in a vast and unknown world, proving that a shared desire for prosperity could be a more powerful unifying force than any empire's army. Just as the vast trade networks relied on contracts to manage risk across continents, the very building of those civilizations, the planting of the fields, the raising of the temples, the crafting of the goods, was also meticulously governed by written agreements for labor. This was a world without a modern concept of employment. There were no standardized job applications or universal hourly wages. Instead, the relationship between someone who needed work done and someone who could do it was a formal, negotiated transaction, captured in the precise language of a contract. These labor agreements were the engine oil that kept the complex machinery of the ancient economy running smoothly, ensuring that massive projects could be staffed and essential harvests gathered on time. They transformed the abstract need for labor into a concrete, manageable, and enforceable obligation. The specifics of these contracts reveal a fascinating and often surprisingly detailed world of ancient work life. In Egypt, where the dry climate preserved fragile papyrus, we have incredibly vivid records. A contract for a skilled artisan working on a royal tomb might not promise a salary of coins, but instead a daily wage measured in tangible sustenance, so many loaves of bread and jugs of beer, along with occasional rations of fish, vegetables, and even ointment. This wasn't a primitive barter system. It was a calculated ration that ensured the worker had the calories and nutrients needed to perform strenuous tasks in the desert heat. The quantity and quality of these rations were often tied directly to the worker's skill level and status. A master sculptor would receive a significantly larger allotment than his apprentice, creating a clear hierarchy reflected in their daily bread. These agreements also specified the tasks expected, perhaps carving a specific set of hieroglyphs or painting a section of wall, and the time frame for completion. This clarity protected the worker from being forced to perform endless, undefined labor, and protected the employer from a worker who might shirk their duties. Meanwhile, in Mesopotamia, the rhythm of labor was often tied to the agricultural calendar. Clay tablets from cities like Umma and Lagash detail the hiring of seasonal workers for the all-important harvest. These contracts were short-term and specific, brought into force for the few frantic weeks when the barley needed to be reaped and threshed. They would list the number of workers required, the duration of their employment, and their payment, which was often a share of the harvest itself. A local official, acting on behalf of the temple or a wealthy landowner, would oversee the process to ensure the terms were met, that the workers put in a full day's labor, and that they received their agreed-upon portion of grain. This system was brilliantly efficient for managing peak labor demands, drawing upon a floating population of workers who moved from estate to estate as the seasons changed. On the surface, this all sounds remarkably fair, even progressive. The contract ensured a meeting of the minds. The worker knew exactly what was expected and what they would receive in return, and the employer had a guarantee that the work would be done. This mutual obligation was the bedrock of economic stability. However, to see only this balanced reciprocity is to miss the deeper, more rigid social structure that these contracts simultaneously reinforced. For many, especially unskilled laborers and those trapped in cycles of debt, these were not agreements between free and equal parties bargaining in an open market. They were often instruments of control. Long-term service contracts could effectively bind a worker and their family to a particular patron or estate for years. The terms might provide security, a guaranteed roof and daily rations, but at the steep cost of personal mobility and freedom. The worker couldn't simply leave for a better offer. They were legally obligated to remain, their life choices constrained by the clay tablet they or their ancestor had sealed. This created a society where your economic freedom was largely predetermined by your birth and social station. The skilled artisan might have some leverage to negotiate his bread and beer ration, but the common field hand did not. His labor was a commodity, and the contract was the mechanism that locked him into his place within a carefully managed economic hierarchy. The system was designed to optimize productivity and maintain social order for the benefit of the state and the elite. It ensured that the pharaoh's pyramid would be built and the nobles' granaries would be filled, but it did so by creating a largely static workforce with limited avenues for upward mobility. The very document that protected a worker's right to be paid also functioned as the legal chain that kept him firmly within his assigned tier of society, a powerful illustration of how ancient law could provide protection and impose limitation in the very same stroke. Of all the legal monuments to survive from the ancient world, none stands taller, both literally and figuratively, than the Code of Hammurabi. Imagine a towering black stone stele over 7 feet tall, discovered in 1901 in what is now Iran. At its top, a bas-relief shows the Babylonian king Hammurabi standing reverently before Shamash, the god of justice, receiving the divine authority to enact these laws. Below this powerful image, column upon column of meticulously carved cuneiform script lays out 282 laws that governed every conceivable aspect of Babylonian life. This was far more than a legal reference manual stored in a palace archive. It was a public declaration, a piece of political theater etched in stone and erected in city centers for all to see. It proclaimed a revolutionary idea that the law was not a secret weapon for the elite, but a known standard, applicable to everyone from the highest official to the humblest merchant. This commitment to transparency was itself a form of justice, ensuring that no one could be blindsided by a rule they didn't know existed. When we zoom in on the provisions related to contracts, the sophistication of Hammurabi's code becomes breathtakingly clear. This was not a primitive set of an eye for an eye punishments. It was a nuanced commercial code designed to create a functioning, trustworthy economy. It introduced principles that are the absolute bedrock of modern contract law. Take the concept of an implied warranty, for example. Law 229 states that if a builder constructs a house for someone and does not build it properly, and the house collapses and kills the owner, then that builder shall be put to death. But it doesn't stop there. Law 230 specifies that if it kills the owner's son, then the builder's son shall be put to death. The principle of proportional and terrifying responsibility is stark. Similarly, a farmer who was negligent in maintaining his irrigation ditch, allowing water to flood and ruin his neighbor's field, was legally obligated to compensate his neighbor for every bushel of grain lost. These laws created a powerful incentive for professionals to do their jobs with care and competence, because the consequences of failure were severe, personal, and legally enforceable. This idea of acting in good faith is another thread woven throughout the code. It wasn't enough to simply follow the letter of an agreement. Parties were expected to act with honesty and fairness. Consider the laws governing loans. The code set a maximum interest rate for loans of grain and silver, attempting to prevent predatory lending that could trap borrowers in inescapable debt. If a debtor lost his crops to a storm or a drought, the code provided for a suspension of the debt repayment for that year, a recognition that some circumstances were beyond anyone's control. This wasn't charity. It was pragmatic economics designed to prevent the total collapse of a farming family who could no longer contribute to the economy. The code even addressed the conduct of tavern keepers, who were predominantly women, stating that if they accepted stolen goods as payment for beer or overcharged their customers, they would face the death penalty. Everywhere you look, the code is trying to engineer a society based on predictable, fair dealings, where the risks and rewards of commerce were clearly defined and brutally enforced. The enduring legacy of Hammurabi's Code, however, lies not in its specific, often brutal penalties, but in its foundational philosophy. It established the radical notion that the ruler had a responsibility to protect the weak from the strong and to ensure justice for all his subjects. The prologue and epilogue of the code are filled with Hammurabi's boasts about his own fairness and his divine mandate to cause justice to prevail in the land and to destroy the wicked and the evil, that the strong might not oppress the weak. This was a powerful piece of statecraft, a way to legitimize his rule by presenting himself as the guardian of order and equity. By inscribing these laws on stone and placing them in public view, he made a promise to his people, a social contract, if you will, that his governance would be based on known, fixed principles, not on his personal whim. This model of public, written law became the gold standard for empires that followed, from the Hittites to the Assyrians, and its echoes can even be heard in the legal foundations of ancient Greece and Rome. It taught the world that for law to be truly effective, it must be seen, it must be known, and it must apply to everyone. But in a world without sprawling bureaucracies or professional police forces to chase down every deadbeat debtor, how did these agreements hold any power at all? The answer lies not in the cold clay of the tablet itself, but in the warm, watchful eyes of the community. The true enforcement mechanism for an ancient contract was a social one, built on a powerful foundation of reputation, shame, and the ever-present fear of divine retribution. Before a single wedge was pressed into the wet clay, the parties would gather, and with them, a carefully selected group of witnesses. This wasn't a casual affair. These witnesses were chosen for their standing. They were often community elders, respected for their wisdom and integrity, or local officials whose word carried the weight of authority. Their names, titles, and sometimes even their seals were meticulously recorded on the tablet, transforming them from passive observers into active guarantors of the agreement. They were the living memory of the deal, the human backup to the written record. To understand the power of this system, you have to step into the shoes of an ancient Mesopotamian. Your world was not a sprawling metropolis of anonymous faces. It was a tightly knit community where everyone knew everyone else's business. Your reputation was your most valuable asset, the currency of your social and economic life. If you broke a contract, it wasn't a private matter. The injured party would immediately appeal to those witnesses. These respected men would then be obligated to testify against you before the local assembly or a royal judge. Your breach of contract would become public knowledge, a stain on your character and your family's name. The legal penalty might be a financial fine, but the social penalty could be far more devastating. Who would want to enter into a contract with a man known to be untrustworthy, who would lend him grain at planting time, who would accept his son as a husband for their daughter? The threat of this social ostracism, of becoming a pariah in your own community, was a far more potent deterrent than any fine. The contract, therefore, bound you not just to the other party, but to the entire community that had witnessed and validated your promise. And if the fear of social shame wasn't enough, there was an even higher authority invoked to seal the deal: the gods. Before the witnesses, the parties would often swear a solemn oath to uphold their end of the bargain, and they wouldn't swear on their own lives, they would swear in the name of a deity. A Sumerian merchant might call upon Shamash, the god of justice and truth, to strike him down if he lied. An Assyrian trader might invoke Ashur, the patron god of his city, to bring ruin upon his household if he defaulted. This was not merely a colorful figure of speech, it was a deeply serious spiritual commitment. In a world where the divine was intimately involved in daily affairs, the belief in immediate and terrible divine punishment was absolute. Perjury lying under oath was considered one of the most heinous sins, an offense that would inevitably call down the wrath of the gods, bringing disease, famine, or death upon the offender, and sometimes their entire family. This spiritual dimension transformed a simple business agreement into a sacred covenant. A man might be willing to risk the anger of his neighbor or even the king's magistrate, but few would dare risk the eternal, unforgiving fury of a god. This powerful blend of legal record, social pressure, and religious fear created a remarkably robust and effective system of enforcement. It meant that even in the absence of a strong central state, a person's word, once given formally and witnessed, became his bond, a bond that held the very fabric of early commerce and society together through a shared sense of honor and collective accountability. But what happened when that sacred bond was broken, when a witness's testimony wasn't enough and the fear of the gods failed to deter a determined cheat? This is where the cold, hard mechanics of ancient justice took over. The penalties for breaking a contract weren't just about punishment. They were a carefully calibrated system designed to restore a sense of balance to the community, a concept the Mesopotamians called kittim, or truth and order. The primary goal was almost always restitution, to make the wronged party whole again. This wasn't a vague ideal, it was a precise mathematical calculation. If a borrower failed to repay a loan on time, the standard penalty was often an additional 33% of the original sum, a hefty fine meant to compensate the lender for the delay and the lost opportunity to use that money elsewhere. For theft, the penalty was frequently to repay double or even triple the value of the stolen goods. This served a dual purpose. It repaid the victim for their loss and the distress caused, and it removed any potential profit the thief might have hoped to gain, making crime an economically irrational choice. However, in a world where many offenders had little wealth to seize, the legal system had other, more brutal tools at its disposal. Physical punishments were common for certain offenses, particularly those that struck at the heart of the system's integrity, like perjury or false accusation. A witness who was proven to have lied under oath might have his tongue cut out, a grimly literal penalty for the sin of speaking falsely. A man who falsely accused another of a crime could suffer the punishment that would have been inflicted on his innocent target. These corporal punishments were public spectacles, designed not just to penalize the individual but to serve as a stark, unforgettable warning to the entire community about the cost of undermining the legal process. For the most severe breaches of contract that amounted to a betrayal of the entire social order, such as an official embezzling temple funds or a merchant consistently selling fraudulent goods, the ultimate penalties could be applied: permanent enslavement for the offender and his family, or exile from the city walls, which was often a death sentence in itself. The actual enforcement of these sentences fell to a surprisingly varied group of authorities. In smaller local disputes, a council of elders from the community would gather to hear the case. They would consult the written contract, listen to the testimony of the witnesses, and render a judgment based on precedent and their own understanding of fairness. For matters involving the state or the temple, a royal official, perhaps a sakalma or chief minister, would act as judge. His authority derived directly from the king, and his verdict was final. There was no professional police force as we know it. Instead, the court would call upon the local rabisu, a kind of constable or bailiff, to carry out its orders. This might involve seizing property, administering a beating, or formally transferring a debtor into the custody of his creditor. This entire process, from the filing of the complaint to the execution of the penalty, was meticulously recorded on yet another clay tablet and stored in the archives, creating a legal paper trail that could be referenced if the dispute ever flared up again. This emphasis on documentation shows a profound belief in the law as a continuous, living record of justice served. Yet, for all its attempts at balance and restitution, we must view this system through the harsh lens of its time. The penalties were undeniably severe by any modern measure. The principle of an eye for an eye from Hammurabi's Code was not metaphorical, it was a literal guide for sentencing. This harshness wasn't born from mere cruelty, but from necessity. These were loosely governed societies with limited capacity for surveillance or incarceration. A strong deterrent was the most efficient tool for maintaining order. The threat of having a hand cut off for theft was a powerful incentive for honesty in a world without locked doors or forensic investigations. Furthermore, the application of justice was rarely blind. The same offense could bring drastically different penalties depending on the social status of the victim and the perpetrator. Harming a nobleman would invariably result in a much more severe punishment than harming a commoner or a slave. The law, while aspiring to kittom, was ultimately a tool of the state, designed to protect property and maintain the existing social hierarchy above all else. It provided a framework for justice, but it was a justice that reflected the stark inequalities and unforgiving realities of the ancient world. While the civilizations of Mesopotamia were building their legal foundations on durable clay, ancient Egypt was developing its own revolutionary approach, harnessing the bounty of the Nile to create a writing medium that would transform record-keeping forever: papyrus. Imagine the stalk of the papyrus plant harvested from the river's edge, sliced into thin strips, soaked, pressed, and dried into smooth, pale sheets. This wasn't just paper, it was a technological leap on par with the invention of the printing press. Lightweight, flexible, and capable of being rolled into scrolls, papyrus turned contracts from heavy, fragile tablets into portable documents that could easily travel the length of the empire, from the bustling delta in the north to the distant Nubian frontier in the south. This portability was the key that unlocked a new level of bureaucratic sophistication, allowing the pharaoh's will to be administered with a consistency and reach that clay could never achieve. The sheer scope of what was recorded on these papyrus scrolls is breathtaking. Egyptian contracts were the arteries of the state, documenting every transaction that kept the civilization functioning. There were meticulous tax assessments, calculating the exact amount of grain owed to the state granaries based on the Nile's annual flood and the size of a farmer's plot. There were contracts for temple donations, where a wealthy official might grant a parcel of land to a priesthood, with the rental income funding daily offerings to the gods in perpetuity. There were leases for state-owned workshops, employment agreements for scribes and artisans, and even contracts for the delivery of specific commodities like linen or wine to the royal palace. This wasn't a system that only concerned the elite. Fragments of papyrus found in workers' villages like Deir el-Medina show detailed contracts between the craftsmen building the royal tombs, outlining agreements for tool sharpening, laundry services, and even the division of stolen loot. The contract was the universal language of obligation, from the highest minister to the humblest laborer. At the heart of this vast bureaucratic machine was a figure of immense importance, the scribe. Trained from youth in the complex hieratic and later demotic scripts, the Egyptian scribe was more than just a clerk. He was the living database, the legal advisor, and the indispensable cog in the state's administrative apparatus. He sat in the temple courtyard or the vizier's office, his palette of red and black inks at the ready, drafting documents with a standardized formulaic language designed to prevent ambiguity. His role was to translate the messy realities of human agreement into the clean, precise, and legally enforceable prose of the state. A single contract for the sale of a donkey, for instance, would be a masterpiece of detail, listing the animal's age, its distinguishing marks, any previous injuries, the names of its parents, the full price paid, and the names of no less than 16 witnesses. This obsession with precision wasn't pedantry. It was the essential ingredient for maintaining order across a vast and diverse kingdom. Once drafted, these documents didn't simply go home with the parties involved. They were deposited into highly organized state archives, immense libraries of rolled papyrus that functioned as the institutional memory of Egypt. Think of these archives as the ancient equivalent of a cloud server, a centralized, secure repository where every agreement could be stored, catalogued, and retrieved at a moment's notice. This was a revolutionary concept. If a dispute arose years or even decades later over a field's boundary or an inheritance claim, a messenger could be dispatched to the nearest regional archive. A scribe would locate the relevant scroll, unroll it, and read the original terms aloud, settling the matter with the immutable authority of the written word. The state, in the form of the pharaoh's officials, was the ultimate guarantor of these contracts, and the archive was the proof. Perhaps no single document better illustrates the breathtaking scale of this system than the Wilbur Papyrus, a scroll over 30 feet long dating from the reign of Ramesses V. This isn't a narrative or a story, it's a massive, dry, administrative ledger, yet within its columns of hieratic script lies a powerful snapshot of the Egyptian state in action. The papyrus meticulously records the measurements, ownership, and tax obligations of thousands of plots of farmland in Middle Egypt. It notes whether the owner is an institution like a temple, a high-ranking official, or even a simple soldier, and it calculates the exact tax due based on the land's productivity. This document wasn't created for reading pleasure. It was a working tool for tax collectors, a master spreadsheet that allowed the central government in Thebes to efficiently extract the agricultural wealth that fed the army, built the monuments, and paid the priests. It shows us that the pharaoh's power wasn't just expressed through colossal statues and towering pyramids, but through the quiet, relentless efficiency of the scribe's pen, turning the fertile black soil of the Nile Valley into a grid of measurable, taxable, and contractually governed assets. The contract in Egypt was the silent engine of empire. Yet for all the meticulous record-keeping of the Egyptian scribes, the true power behind these ancient agreements often came from a source far beyond the palace walls or the tax collector's ledger. To understand why a promise etched in clay or written on papyrus held such immense, unshakable weight, we must look upward to the gods themselves. In the minds of the ancients, the law was not a human invention. It was a divine gift, a sacred order woven into the very fabric of the universe. A contract was therefore more than a simple transaction. It was a religious act, a covenant made under the watchful eyes of heaven. This profound spiritual dimension transformed every agreement from a mundane matter of commerce into a solemn vow with eternal consequences. This fusion of the legal and the divine is vividly clear in the language of the contracts themselves. A Sumerian merchant finalizing a sale of land wouldn't just list the price and the witnesses. He would invoke the god Shamash, the celestial judge, to strike down any party who dared to alter the terms or break their word. A Hittite treaty between two kings wouldn't merely outline borders and tribute. It would include elaborate curses, calling upon a pantheon of deities to unleash famine, disease, and defeat upon the nation that betrayed its oath. The gods were named as the ultimate enforcers, the guarantors of truth in a world where human authority could only reach so far. This wasn't poetic flourish, it was a genuine and deeply held belief that to break a contract was to commit a sin, an offense that would inevitably attract divine retribution. The spiritual stakes raised the cost of betrayal to an unimaginable height, making a sworn promise perhaps the most binding force in ancient society. The physical spaces where these documents were created and stored further underscore this sacred connection. Temples were not just places of worship, they were the primary archives and notarial offices of the ancient world. The inner courtyards of a ziggurat in Ur or a temple complex in Thebes were where scribes drafted contracts, and it was often in the temple's secure vaults that the original documents were stored for safekeeping. This practice sent a powerful message. The agreement was under the divine protection of the temple's god. To later challenge the terms of a contract might require returning to that sacred space and swearing an oath before the god's statue, a terrifying prospect for any pious individual. The priests themselves played a crucial dual role, serving as both spiritual intermediaries and legal arbiters. They were the experts in the ritual formulas that made a contract valid, and they were often the judges called upon to settle disputes that arose from them. Their authority came from their unique position astride two worlds. They understood the will of the gods and the laws of men. This system created a powerful, self-reinforcing cycle of compliance. A person might be tempted to cheat another human, to renege on a debt or claim a field that wasn't theirs. But the same person would likely be far more hesitant to risk the wrath of a god like Shamash or Ishtar, whose punishment could extend to their entire family and future generations. The fear of divine justice acted as a constant, invisible police force, ensuring accountability in countless daily transactions that no royal official could ever hope to monitor. It fostered a culture where a person's word, once sworn in a deity's name, became their absolute bond. This wasn't blind superstition. It was a brilliantly effective social technology. By anchoring the secular needs of commerce and law in the timeless realm of the sacred, ancient societies built a foundation for trust that was both psychologically profound and remarkably durable, enabling cooperation and complexity on a scale that would have been impossible through human authority alone. But if we peel back the layers of these ancient agreements, we uncover a more complex and often darker truth. The contract was rarely a tool of equality. Far from being a neutral instrument of justice, it was often the very mechanism used to cement and enforce the rigid social hierarchies that defined the ancient world. The law did not see everyone as equal before its gaze. Instead, it meticulously calibrated a person's rights, protections, and value based on their birth, gender, and social standing. This wasn't an accidental byproduct of these systems. It was their intended function. The law was designed to maintain order, and that order was built upon a foundation of accepted and legally enforced inequality. This principle is starkly evident in the penalties prescribed for harm. Consider the infamous laws within Hammurabi's Code. If a nobleman were to strike another nobleman of equal status, the penalty might be a financial fine. But if that same nobleman struck a commoner, the punishment was drastically reduced, perhaps a smaller fine or even a simple warning. The logic was cold and economic. The loss of a commoner's labor was less damaging to the social fabric and the state's economy than the loss of a nobleman's. The value of a life and the compensation owed for its loss was literally written into the law based on social class. This legal codification of human inequality meant that justice was not blind. It was keenly sighted and always looking to see who held power. Nowhere is this hierarchical enforcement more vividly detailed than in the Roman law of the 12 Tables, established around 450 years before the Common Era. While a monumental step towards a published legal system, the 12 Tables were unequivocally a document created by the patrician elite to serve their interests. The laws explicitly enforced the vast gulf between the privileged patrician class and the common plebeians. Patricians could dictate crushing terms of debt to plebeians who had little recourse. The law sanctioned a form of debt bondage known as nexum, where a defaulting plebeian could be seized by his patrician creditor and forced into literal chains and hard labor, not for a set term, but until the debt was worked off. This legal framework didn't just reflect the social hierarchy, it actively weaponized it, giving the wealthy and powerful the full backing of the state to exploit those beneath them. This pattern of legally mandated inequality repeated itself across the ancient world. In India, the Manusmriti, or laws of Manu, provided a comprehensive legal and social code that prescribed entirely different rules for the four main castes. A contract's validity, the weight of a man's testimony in court, and even the punishment for a crime were all determined by the caste of the individuals involved. A Brahmin could never receive the same punishment as a Shudra for the same offense. The system was designed to be immutable, with contracts and laws acting as the bars of a social cage, ensuring everyone remained in their divinely ordained place from birth until death. And for women, the limitations were often even more profound. While we've seen that marriage contracts could offer some protections, a woman's ability to engage in legal agreements independently was almost universally restricted. In many Mesopotamian societies, a woman required a male guardian, her father, husband, or son, to co-sign or authorize any significant contract for the sale of property or the taking of a loan. In Athens, a woman was considered a perpetual legal minor, forever under the guardianship of a Kyrios or lord who controlled her economic life. Her consent was often a legal formality, if it was required at all. These weren't mere social customs. They were binding legal principles that systematically excluded half the population from full participation in the economic and legal life of their own communities, ensuring wealth and property remained concentrated in the hands of men. Yet, for all its oppressive capacity, the contract also held a flicker of potential for those with the wit to use it. The very existence of a written, enforceable agreement created a sliver of space for agency. A clever merchant from a humble family could, through a series of shrewd partnership contracts, slowly amass enough capital to elevate his status. There are records of successful Mesopotamian businesswomen, often widows who inherited their husband's estate, who then used contracts to manage their own commercial enterprises, lending silver and buying property in their own name. Even the Roman plebeians, after years of struggle, used their collective power to force the patricians to reform the harsh debt laws of the 12 Tables. The contract, the very tool used to bind them, became their instrument for demanding better terms. This is the fascinating duality at the heart of ancient law. It was a conservative force, a powerful brake on social change designed to preserve the status quo and the power of the elite. but it was also a tool, and tools can be picked up by anyone. The predictability and formality of the contract created a platform, however uneven, where a person's economic acumen could sometimes, just sometimes, outweigh the disadvantages of their birth. It provided a language of negotiation and obligation that, while stacked in favor of the powerful, was still a language that could be learned and spoken by those below. The law was thus a battlefield, a constant tension between the impulse to freeze a social order in place and the human desire to use the rules of the game to forge a better path forward. This drive for precision transformed the very language etched into clay and papyrus, shifting from storytelling to a structured, repeatable formula. The earliest contracts read like miniature narratives, almost like a scribe was trying to capture the entire scene. A typical Sumerian agreement might begin by setting the stage. In the year the king built the temple of Enlil, in the month of the barley harvest, when the sun was high in the sky, Sin-Idunum, the son of Awil-Ishtar, approached Lu-Inanna, the son of Ur-Nammu, and spoke thusly. It was a full account, rich with context, but also ripe with potential ambiguity. What if someone questioned the exact date? What if a key detail was buried in the prose? As transactions multiplied and societies grew more complex, this narrative style became too cumbersome and too vulnerable to misinterpretation. Scribes, the original legal draftsmen, began to develop a solution: standardization. They started boiling down agreements into their most essential, repeatable elements, creating what we would now recognize as legal clauses. This wasn't a loss of creativity, it was a leap in legal engineering. They crafted formulaic phrases for every conceivable situation. A standard clause for the sale of a house would always include the same components in the same order: the names of the seller and buyer, a precise description of the property including its boundaries and adjacent owners, the purchase price, the list of witnesses, and the date. This repetitive structure had a brilliant effect. It drastically reduced the chance of error or omission. A scribe could almost draft a contract from memory, slotting in the specific names and amounts, confident that the foundational legal framework was sound and universally understood. This consistency made contracts faster to produce, easier to read, and far simpler to adjudicate. A judge could glance at a tablet and immediately find the crucial information because he knew exactly where in the formula it would be located. This march toward uniformity extended beyond the text itself to the very methods of authentication. In the early days, a cylinder seal impression was a personal mark, but its placement and the accompanying text could vary. Over time, the practice became rigorously formalized. The contract would specify that the parties had rolled their seals in the presence of the witnesses, and the witnesses themselves would often add their own seal impressions or be listed in a specific hierarchical order. The dating formula also evolved from a descriptive event, the year after the Great Flood, to a standardized system using the regnal years of the current king, providing an unambiguous chronological anchor. This entire apparatus of seals, witness lists, and dates created a powerful system of verification. A judge presented with a contract could quickly assess its validity by checking for these standardized authenticating features. If a seal was missing, if a witness was not listed, or if the date was formatted incorrectly, it could cast doubt on the entire document's legitimacy. This system was the ancient equivalent of a notary stamp, a corporate logo, and a digital signature all rolled into one, designed to build trust and prevent fraud in a world where documents could determine the fate of families and fortunes. This relentless refinement of language and form, this centuries-long project of distilling human agreements into clear, predictable, and enforceable terms, laid the essential groundwork for the complex legal systems that govern our globalized world today. Across the vast expanse of Eurasia, while Mediterranean societies were refining concepts of individual consent and good faith, an entirely different philosophy of law was taking root in ancient China. Here, the purpose of a contract was not to facilitate personal agreement between parties, but to serve as an instrument of state control, a tiny cog in a vast bureaucratic machine designed for one overriding purpose: stability. This worldview was shaped by legalism, a pragmatic and often ruthless philosophy that dismissed Confucian ideals of virtue and tradition in favor of clear, strict, and uniformly applied laws backed by the absolute power of the state. Legalists like Shang Yong and Han Fei believed humans were inherently selfish and short-sighted, and could only be compelled to act in the interests of social order through a system of rigid rules and severe, inescapable punishments. In this framework, a contract was not a sacred covenant between individuals and their gods. It was a regulatory document, a tool for the central government to monitor, manage, and control economic activity from the imperial capital down to the smallest village. The practical application of this philosophy reached its zenith during the Qin and Han dynasties. The first emperor, Qin Shi Huang, a fervent legalist, unified China and immediately set about standardizing everything: currency, weights, measures, cart axles, and most importantly, the written script. This obsession with uniformity was the absolute bedrock of the Chinese contractual system. A contract for the sale of a parcel of land in the northern province of Yan had to be written in the same format, using the same characters, and referencing the same units of measurement as a contract for a bolt of silk in the southern lands of Chu. This allowed officials anywhere in the empire to understand and enforce the terms without ambiguity or local interpretation. The documents themselves were typically inscribed on durable bamboo slips, bound together with cord to form a scroll, or sometimes written on precious silk for the most important agreements. Unlike Mesopotamian tablets stored in temple archives or Egyptian papyri held by private scribes, these contracts were meant to be deposited in government offices. They became part of the state's permanent record, a way for the bureaucracy to keep its finger on the pulse of every significant transaction within its borders, and to prevent disputes from ever arising by having an immutable, state-sanctioned record. Perhaps the most striking feature of these Chinese contracts, and the one that most clearly reveals their legalist DNA, was the principle of collective responsibility. This concept, known as Biogia or the mutual surveillance system, held that individuals were not solely accountable for their own actions. If a man defaulted on a loan or breached a contract, the liability did not fall on him alone. It extended to his entire family and often to his neighbors in a grouped household unit. This created a powerful, peer pressure-based enforcement mechanism. Your family and your community had a vested interest in ensuring you fulfilled your contractual obligations, because your failure would bring punishment and shame upon them all. This system brilliantly outsourced the work of enforcement from a limited core of government officials to the population itself, fostering a culture of constant mutual monitoring that prioritized the collective good, or more accurately, the state's definition of order over individual desire or misfortune. This stands in stark contrast to the legal evolution happening in the West. While Roman law was meticulously distinguishing between different types of contractual consent and developing the idea of a meeting of the minds between independent parties, Chinese law was focused on the group. The individual was significant primarily as a member of a family, a village, and a state. A contract was less about the will of the individuals involved and more about their duty to maintain social and economic stability as defined by the emperor and his administrators. The goal was not to empower individuals to make agreements, but to use agreements to bind individuals more firmly into the hierarchical structure of the state. This created a society that was incredibly stable and resilient over long periods, but often at the cost of personal freedom and individual legal rights. The contract in the hands of the legalist state became a chain of obligation that linked the individual to the family to the village, and the village directly to the immense, impersonal, and unassailable power of the imperial bureaucracy. Behind every durable clay tablet and every crisp papyrus scroll stood a figure of immense skill and authority, the individual who truly made the system function, the scribe. To become one was to embark on a path of grueling intellectual discipline, a journey that began in childhood within the walls of a scribble school. In Mesopotamia, these institutions were known as adubas, literally tablet houses, and they were far from casual classrooms. A typical day for a young student or dubsar involved long hours of painstaking repetition, copying and reciting hundreds of cuneiform signs until the wedge-shaped marks became as natural as breathing. The curriculum was brutally rigorous, combining what we would now separate into distinct fields of study. A scribe didn't just learn to write, he had to achieve fluency in multiple languages, master complex mathematical calculations for interest rates and land area, and internalize the vast and ever-growing body of legal precedents and formulaic clauses. Discipline was harsh, with canings common for sloppy work or laziness, a reflection of the high stakes awaiting them in the professional world. This education was a gateway to a prestigious career, but it was a gate fiercely guarded by years of relentless study and practice. Upon graduation, the scribe stepped into a role that was a unique fusion of modern professions. He was part lawyer, part notary public, part accountant, and part archivist. When two parties sought to formalize an agreement, they didn't draft it themselves. They went to a professional scribe. His first task was that of a legal advisor, listening carefully to the terms of the deal, and then translating that oral understanding into the precise, unambiguous language of the law. He had to select the correct contractual formula from memory. Was this a Ernamu loan agreement with interest, or a taputum partnership for a trading venture? He would then meticulously inscribe the names of all parties, the exact nature of the goods or services, the price, the payment schedule, and the penalties for default. But his most crucial addition was the list of witnesses. The scribe knew which community elders or officials would lend the document the greatest credibility, and he ensured their names and seals were properly recorded. A single mistake, a misspelled name, an incorrect measurement, an omitted witness could render the entire contract void or lead to bitter and costly litigation. The scribe's reputation, and indeed his livelihood, depended on his flawless precision. This expertise placed scribes among the elite of ancient society. They were highly compensated for their services, charging significant fees that allowed them to accumulate wealth and property. In Egypt, a skilled scribe was famously advised in a text called the Satire of the Trades to look down upon less fortunate professions. Be a scribe. It saves you from toil and protects you from every kind of work. You are the one who gives orders. They enjoyed a lifestyle free from manual labor, often serving directly in the households of nobles, in temple complexes, or within the royal palace itself. Their value to the state was incalculable. They were the administrators who recorded tax revenues, the clerks who tracked military supplies, and the diplomats who drafted treaties with foreign powers. Their command of the written word granted them a form of power that was both subtle and immense, as they controlled the very medium through which reality was officially recorded and remembered. The long-term impact of this professional class cannot be overstated. By creating a standardized, reliable process for documenting agreements, scribes introduced a powerful element of objectivity and consistency into the legal system. An oral promise could be misremembered, distorted, or outright denied. A written contract drafted by a neutral third-party expert and stored in an official archive created a permanent, unassailable record of truth. This allowed for the resolution of disputes based on evidence rather than on which party could muster the most persuasive witnesses or the greatest social influence. It enabled the law to become more predictable, which in turn encouraged economic activity and investment, as people could engage in complex transactions with a much higher degree of confidence. The scribe, in his quiet diligence, was the human engine that transformed the abstract concept of justice into a tangible, working reality, building a foundation of trust, one carefully inscribed character at a time. But to truly grasp the revolutionary nature of Roman contract law, we have to leave behind the simple notion of a written deal and step into a more abstract and powerful world of mutual understanding. The Romans, with their characteristic legal genius, moved beyond the physical document to pioneer two concepts that are the absolute bedrock of modern contract law: consensus ad idem and bona fides, the meeting of the minds and good faith. This was a seismic shift. It meant that a contract's power no longer resided solely in the ceremonial utterance of specific words or the pressing of a seal into wax. It now lived in the invisible, mutual intention of the parties involved. If both a buyer and a seller genuinely agreed on the same thing, the same object, the same price, the same terms, then a binding obligation was created, even if no money had changed hands and no tablet had been inscribed. This idea elevated contract from a formal ritual to a moral and philosophical principle, recognizing that the true engine of agreement was a shared intention, a mental handshake that the law had a duty to protect. Furthermore, the principle of bona fides, or good faith, infused every step of this process. It wasn't enough to just technically agree. Both parties were expected to act with honesty, fairness, and a genuine commitment to seeing the agreement through. A seller was legally obligated to disclose hidden defects in a slave or a piece of land. A partner in a business venture had a duty to faithfully account for all profits and losses. This wasn't just a vague ethical suggestion, it was an enforceable legal standard. A Roman judge or iudex presiding over a contractual dispute was expected to dig into the specifics of the case and ask, did both parties act in good faith? Was there a true meeting of the minds? This allowed for a flexibility and fairness that rigid, formulaic systems lacked. The law could now address the spirit of the agreement, not just the black and white letter, adapting to an almost infinite variety of human dealings across a vast and diverse empire. This sophisticated framework didn't spring into existence fully formed. Its origins were surprisingly humble, rooted in the struggle for rights between the privileged patrician class and the common plebeians. The law of the 12 tables, carved onto bronze tablets around 450 years before the Common Era, was a hard-won victory for the plebeians, forcing the elite to publish the laws so they could no longer be arbitrarily applied. While primitive in many ways, it still sanctioned debt bondage and was fiercely focused on procedure. It established crucial first principles. It set down basic rules for formal verbal contracts and for transferring property, creating a publicly known standard that applied to all Roman citizens. This was the essential seed, the acknowledgement that a society needed predictable, published rules to function. For centuries after, the real work of building contract law was done not by legislators, but by a remarkable class of legal experts known as jurists, men like Gaius, Ulpian, and Papinian. These were brilliant intellectuals who advised judges, gave legal opinions, and most importantly, began to systematically categorize the chaotic world of human agreements into a logical, coherent structure. Their great innovation was a system of classification that is still taught in law schools today. They sorted all contracts into 4 elegant categories based on how the obligation was created. Verbal contracts stipulatio were formed through a precise, ritualistic question-and-answer ceremony. Literal contracts were based on an entry in a ledger book, a formal accounting of a debt. Real contracts came into existence simply through the handing over of a thing, a loan, a deposit, or a pledge. And most importantly for commerce, there were consensual contracts which required no formalities at all. These including sale, lease, partnership, and mandate, a kind of agency agreement, were binding through mere consent, the purest expression of consensus ad idem. This was the law catching up with the frantic pace of Mediterranean trade. A merchant in Alexandria could now make a binding deal with a shipowner in Ostia simply through an exchange of letters, confident that the full force of Roman law would uphold their agreement, even though they were 1,000 miles apart and had never shaken hands. This legal clarity and enforceability became the Roman Empire's secret weapon, the grease that allowed the wheels of commerce to spin from the rainy frontier of Britain to the bustling markets of Syria, creating a truly integrated economic zone. The culmination of this centuries-long project of legal refinement arrived under the ambitious Emperor Justinian in the 6th century. Though the western half of the empire had fallen, Justinian was determined to reclaim Rome's glory and needed a unified legal code to govern his vast domains. He tasked his minister, Tribonian, with a monumental project to compile, edit, and systematize over 1,000 years of Roman law into a single, authoritative corpus. The result, the Corpus Juris Civilis, or the body of civil law, was nothing short of a miracle of legal preservation and organization. It digested the entire works of the great jurists, reconciling contradictions and distilling the essence of Roman legal thought, including its incredibly advanced law of contracts, into a coherent whole. This massive work didn't just look backward, it was a living code that continued to develop new laws. Forged in the fading days of the empire, the Corpus Juris would ironically become its most enduring export. Preserved and studied in the East, it was rediscovered in Western Europe centuries later in the great medieval universities of Bologna and Padua. It provided the sophisticated framework that nascent European nations desperately needed to move beyond feudal customs and build modern states. The Roman concepts of good faith, consent, and contractual categories became the common language of European law, and through colonization spread across the globe. Every time a modern court enforces an agreement based on a mutual meeting of the minds, it is speaking the language of those Roman jurists, proving that the empire's most powerful and lasting legacy was not its roads or its aqueducts, but the revolutionary idea that a promise between two people, fairly made, deserved the unwavering protection of the law. It's astonishing to realize that the legal documents we encounter today, the dense pages of a mortgage agreement, the terms of service for a new app, even the simple act of clicking "I agree" online, are all distant echoes of those first marks pressed into Mesopotamian clay. The fundamental architecture of modern contract law wasn't invented in a vacuum by Enlightenment thinkers. It was painstakingly assembled over millennia, with its deepest foundations resting on principles forged in the ancient world. Consider the most basic building block of any agreement, the concept of offer and acceptance. This idea that a contract is formed when one party makes an offer and another unequivocally accepts it isn't a modern legal theory. It's a direct descendant of Roman law's consensus ad idem, the meeting of the minds. The Romans understood that for a promise to be binding, There had to be a genuine, mutual intention between the parties. They moved the focus from rigid rituals to the actual agreement itself, a revolutionary shift that allowed commerce to flourish with a flexibility that formal ceremonies could never provide. This principle is why your signature on a lease or your click on a digital button carries legal weight today. The law is recognizing that a mutual understanding has been reached, continuing a tradition of validating consent that is thousands of years old. Then there's the doctrine of consideration, that peculiar but essential rule which states that a contract isn't valid unless something of value is exchanged. You can't simply promise to give someone a gift and be legally forced to follow through unless they've given you something in return. This concept, which can seem like a technicality to the uninitiated, has its roots in the very practical concerns of ancient merchants and lawmakers. In both Mesopotamian and Roman law, an agreement without an exchange was often seen as a bare promise, a nudum pactum, and therefore unenforceable. The law required a quid pro quo, a something for something, to distinguish a serious commercial bargain from a casual statement of intent. This was a practical solution to a common problem: how to filter out which promises were worth the court's time to enforce. The ancient world was filled with people making grand claims and casual vows. The requirement of consideration acted as a filter, ensuring that only those agreements where both sides had skin in the game, where a real economic commitment had been made, would be taken seriously by the legal system. This ancient filter is still hard at work in courtrooms today, determining which promises rise to the level of a contract, and what happens when that solemn promise is broken. The entire concept of a breach of contract and the remedies that follow is another ancient inheritance. Hammurabi's Code didn't use the modern legal term, but its provisions were obsessed with what we would call breach. If a builder's shoddy work caused a house to collapse, the code specified the builder's penalty. If a farmer neglected his irrigated field and caused a neighbor's crop to fail, he had to compensate for the loss. The primary goal was restitution, to put the injured party back in the position they would have been in had the contract been performed. This is precisely the same goal that guides modern courts when they award damages for a breach. We've moved away from the draconian physical punishments of the past, but the underlying principle remains unchanged. A broken agreement creates an imbalance that the law has a duty to correct, to restore the fairness and order that the contract was meant to provide. Even the specific language we use carries the dust of antiquity. Take the term force majeure, a clause found in everything from construction contracts to concert tickets. This French term, meaning superior force, is the direct heir of the risk allocation clauses found in Assyrian trading contracts. Those ancient tablets explicitly absolved merchants of liability if their goods were lost to an act of God or the king's enemy, that is, to unforeseen and uncontrollable events like a storm, a shipwreck, or bandit attacks. The fundamental human understanding that some risks are simply too great and unpredictable for any one party to bear was codified in clay long before it was written on parchment or encoded in digital text. This continuity demonstrates that ancient societies weren't just creating arbitrary rules, they were developing sophisticated, pragmatic solutions to universal problems of commerce and risk, solutions so effective that they have endured virtually unchanged for thousands of years. This profound legacy reveals a powerful truth about the nature of law itself. We often think of legal systems as static codes handed down from on high. But studying the evolution of the contract shows us that law is a living, evolving human invention. It is a technology for building trust and facilitating cooperation between strangers, a technology that has been constantly adapted and refined to meet the changing needs of society. The clay tablet became the papyrus scroll, which became the vellum deed, which became the printed document, which became the digital signature. But through every transformation, the core human challenges remain the same. How do we make a promise binding? How do we ensure fairness? How do we enforce an agreement without resorting to violence? The answers developed by ancient scribes, jurists, and merchants have proven to be remarkably resilient, providing a stable foundation upon which ever more complex societies could be built. Our modern global economy, with its intricate web of instantaneous transactions and international deals, ultimately rests on the bedrock of a promise first etched into wet clay under the burning Middle Eastern sun, a testament to humanity's enduring quest for order and trust. Hollywood would have us believe that ancient justice was a capricious and bloody affair, a world where kings decreed death on a whim and might always made right. While the specter of harsh punishment certainly existed, the day-to-day reality revealed by thousands of surviving contracts is one of remarkable nuance, practicality, and even a surprising focus on reconciliation. The law was not merely a blunt instrument of state power, it was a finely tuned tool for maintaining social harmony and economic stability. Take, for instance, the common misconception that every transgression was met with brutal physical retribution. While codes like Hammurabi's famously included the principle of an eye for an eye, a closer look at the actual court records and contracts shows that this was often a last resort, a maximum penalty designed to deter the most serious offenses. In the vast majority of civil disputes over a breached sales agreement, a damaged field, or an unpaid debt, the system's primary goal was not to punish but to restore balance. The preferred outcome was nearly always compensation. A farmer who accidentally flooded his neighbor's field wasn't summarily executed. He was taken to court and ordered to repay his neighbor the exact value of the ruined barley, measured mina for mina. This wasn't about vengeance, it was about repairing the tear in the social fabric and ensuring that the victim was made whole, a principle of restorative justice that feels far more modern than medieval. Another deeply ingrained myth is that these complex legal instruments were the exclusive domain of kings, priests, and wealthy merchants. The dusty fragments tell a very different story. While the grandest archives were indeed housed in temples and palaces, archaeologists have unearthed countless contracts from far more humble settings. In the ruins of ordinary houses in Mesopotamian cities like Nippur or in the workers' village of Deir el-Medina in Egypt, we find contracts for the most mundane aspects of daily life. A farmer leases a single ox for the plowing season, specifying the days of work and the share of the harvest that will serve as payment. Two neighbors formally agree to share the cost of maintaining the irrigation ditch that runs between their properties. A widow loans out a small amount of her precious silver to a relative, drawing up a contract with witnesses to ensure it will be repaid. These were not the dealings of a privileged elite, but the essential economic paperwork of common people, proof that the concept of a binding, written agreement had trickled down to every level of society. The law was not a remote edict from on high. It was a practical resource available to the butcher, the baker, and the candlestick maker, used to bring clarity and security to their everyday transactions and relationships. Perhaps the most surprising revelation is that these ancient systems were not the rigid, unyielding monoliths we often imagine. They possessed a built-in flexibility, an understanding that life is unpredictable and that sometimes even the most solemn promise needs to be adjusted in the face of forces beyond human control. We have numerous examples of what we would now call force majeure clauses or provisions for act of God events. A series of contracts from the ancient city of Mari show debt agreements being officially suspended or forgiven by royal decree following a devastating plague or a failed harvest that made repayment impossible. The king understood that squeezing debt from a starving population was a recipe for rebellion, so the law adapted to preserve the greater social order. Similarly, contracts for long-distance trade often included specific clauses that voided the agreement if a ship was lost at sea or a caravan was wiped out by bandits, recognizing that the merchant should not be held liable for unforeseeable catastrophes. This capacity for mercy and practical adaptation shows a legal mind that was not just about cold enforcement, but about sustaining a functioning society through good times and bad. Dispelling these myths does more than just correct the historical record. It allows us to see these ancient civilizations not as crude and brutal experiments in governance, but as sophisticated societies grappling with the same core dilemmas we face today. They were striving to find that delicate equilibrium between justice and mercy, between the unwavering authority of the law and the unpredictable realities of human life. Their solutions prioritizing compensation over punishment, extending legal access to common people, and building flexibility into their agreements reveal a deep-seated pragmatism and an enduring concern for fairness. When we look past the dramatic tales of eye for an eye justice, we find a legal world that is deeply familiar, one where the primary goal was to resolve disputes, enforce obligations, and build a framework of trust that allowed their world to prosper. These values of practicality, accessibility, and fairness are not ancient relics. They are the very pillars upon which our own modern legal institutions are built, a timeless testament to humanity's persistent quest for order and equity. Yet for all our sophisticated theories about the ancient world, the most profound truths often come not from history books, but from the dirt itself. The entire field of ancient contract law is built upon a foundation of archaeological discovery, a patient, piece-by-piece reassembly of a puzzle shattered by millennia. Each time a spade turns up a new trove of tablets or a sealed jar of papyri, we are granted a rare and direct audience with the past, offered an unedited glimpse into the precise mechanics of daily life that no royal chronicle or epic poem could ever provide. These aren't just artifacts, they are frozen moments of human intention, waiting in the silence for a modern scholar to decipher their secrets and allow the long silent voices within to speak again. Few discoveries have been as transformative as the unearthing of the library of Ashurbanipal in the ancient Assyrian capital of Nineveh. Imagine the scene in the 1850s when archaeologists, led by Austin Henry Layard, began to uncover room after room of this 7th century royal archive. They weren't finding gold or jewels, they were finding clay. Tens of thousands of cuneiform tablets, meticulously organized and preserved, formed the reference library of one of the ancient world's most fearsome and sophisticated rulers. Among the epic poems and omens were countless legal and economic documents, contracts for everything from the sale of slaves to the provisioning of the vast Assyrian army. This was a bureaucratic goldmine. It revealed a state apparatus run with an almost modern efficiency, its authority flowing through a river of written agreements that governed the empire from its glittering core to its farthest provinces. The library didn't just tell us what the laws were, it showed us how they worked on the ground in stunning, granular detail, forever changing our understanding of how an iron-fisted empire was actually administered through the humble power of the written word. Equally illuminating are the Elephantine papyri, a collection found on an island in the Nile that served as a remote military outpost for a Jewish community in the 5th century before the Common Era. These documents, written on papyrus in Aramaic, are a testament to the complex multicultural reality of life under the Persian Empire. Here, far from the centers of power, we find a community using contracts to navigate a world of overlapping identities and legal systems. There are marriage contracts that blend Jewish customs with Egyptian legal formulas, and property deeds that show these soldiers owning land and engaging in commerce with their Egyptian neighbors. Most strikingly, there are letters and petitions showing this community appealing directly to the Persian governor and even to the high priest in Jerusalem for permission to rebuild their temple, which had been damaged in a riot. These aren't the grand pronouncements of kings, they are the paperwork of ordinary people, using the tools of contract and legal petition to protect their community, their property, and their faith in a distant and often precarious land. They show us how law was lived and adapted on the frontier, a fluid instrument for survival and identity. Perhaps the most thrilling aspect of these discoveries is their capacity to completely upend our historical assumptions. For decades, scholars believed sophisticated concepts like maritime insurance were inventions of the Renaissance era. That was until they began translating contracts from the port city of Ugarit, a vibrant trading hub on the Syrian coast that flourished until its sudden destruction around 1180 before the Common Era. The tablets found there describe intricate shipping agreements that included clear risk-sharing clauses. If a ship was lost to a storm or pirates, the loss was shared between the ship's owner and the merchants whose goods were aboard. The cargo wasn't just merchandise, it was a calculated risk, a financial instrument. This wasn't a primitive system, it was a highly developed commercial practice that allowed merchants to engage in risky long-distance sea trade with a safety net, proving that the roots of modern finance are far, far older than we ever imagined. Similarly, the archives of Ebla, a kingdom in 3rd millennium Syria, forced a dramatic rewrite of the history of international relations. Before their discovery, the world of early Bronze Age Mesopotamia was thought to be a collection of isolated city-states. The Ebla tablets revealed a stunningly different picture, a dense web of diplomatic and commercial treaties stretching across the region. There were elaborate contracts for the exchange of luxury goods like lapis lazuli from Afghanistan and silver from Anatolia, complete with detailed protocols for royal gifts and diplomatic marriages. These were not simple barter deals, they were binding international agreements that established terms of trade, guaranteed safe passage for merchants, and forged political alliances between powerful kingdoms. They reveal a world already deeply interconnected by the cold, hard logic of contractual obligation, a world where a king's power was measured not just by his army, but by the strength of his commercial partnerships and the credibility of his written word. This ongoing detective work, this patient sifting of earth and text, is a powerful reminder that history is not a fixed story written in stone. It is a dynamic, evolving narrative, constantly being revised with every new fragment unearthed. Each contract pulled from the ground is a direct window into the mind of an individual who lived thousands of years ago, their fears, their ambitions, their meticulous calculations for the future. We see the farmer worrying about drought, the father securing his daughter's future, the merchant braving the open sea. These documents bridge the chasm of time, transforming our anonymous ancestors from abstract figures into recognizable people who faced the same fundamental human needs for security, prosperity, and trust. They built their world not on abstract ideals but on the tangible, enforceable promise, and in doing so, they left behind the very blueprints that would allow us, millennia later, to walk through the doors of their lives and understand how they made their civilization work. Now, if we pull back from any single civilization and place these ancient contracts side by side, a fascinating pattern emerges, a story of both profound unity and striking diversity in how humanity learned to bind itself with words. It's like looking at a dozen different architects' blueprints for solving the same fundamental problem: how to create trust between strangers. Every society we've explored, from the banks of the Tigris to the Italian peninsula, arrived at the same brilliant, non-violent technology, the written agreement. They all recognized that for a community to grow beyond a small village, for trade to span continents, you needed a system to manage risk, enforce promises, and resolve disputes without resorting to feuds or force. This is the universal pattern, the shared human ingenuity that allowed civilizations to scale. But the moment we look closer at the details, the cultural fingerprints become unmistakable. Each civilization poured its deepest values, its unique worldview, into the clay of its contracts, creating legal traditions that were anything but carbon copies. Take Rome, for instance. Roman law, with its sophisticated categories of consensual, verbal, literal, and real contracts, was fundamentally obsessed with the individual. The entire system was built on the concept of consensus ad idem, the meeting of the minds. The law concerned itself with the intention of the parties, the will of the free citizen to enter into a bargain. This focus on individual consent and agency created a legal environment that was incredibly flexible and empowering for the Roman citizen, fueling a dynamic commercial empire where a deal made in Spain could be enforced in Syria based on the mutual understanding of two people. Now cross the world to ancient China, particularly under the influence of legalist philosophers during the Qin and Han dynasties. Here, the contract served an entirely different master, the collective as embodied by the state. The individual's desires were secondary to the paramount goal of social stability and bureaucratic control. A contract was less about personal consent and more about dutifully fulfilling your role within a vast hierarchical system. This philosophy was brutally enforced through practices like collective responsibility, where an entire family or village could be held liable for one member's breach of contract. The Chinese system brilliantly engineered societal harmony, but it did so by subordinating the individual will to the needs of the group, creating a powerful, centralized state that could administer its empire with ruthless efficiency. Meanwhile, back in Mesopotamia, the cradle of it all, we see a third path, one that beautifully wove together the threads of commerce and divinity. A Mesopotamian contract was never a purely secular affair. It was a tripartite agreement between two people and their gods. The names of deities like Shamash, the god of justice, were invoked not as a mere formality, but as the ultimate guarantors and enforcers of the terms. The temples were the archives, the priests were often the arbiters, and to break your word was to risk divine retribution. This fusion created a powerful moral and spiritual weight behind every transaction, making a business deal simultaneously a sacred covenant. It was a system that managed to feel both profoundly spiritual and intensely practical, a reflection of a world where the divine was intimately involved in the marketplace. These foundational differences were not mere historical quirks. They set in motion legal traditions that continue to shape our world today. The Roman emphasis on individual rights and consent is the direct ancestor of the civil law systems that dominate continental Europe and Latin America, and it heavily influenced the common law tradition of the English-speaking world. The Chinese prioritization of state authority and collective harmony continues to resonate in the legal and bureaucratic structures of East Asia, and the Mesopotamian model, while its direct lineage is harder to trace, reminds us of the enduring human desire to ground our most important promises in something greater than ourselves. This incredible diversity is a powerful antidote to the idea that there is one single correct way to do law. Instead, it reveals law as a cultural artifact, a mirror reflecting each society's deepest priorities and its answers to fundamental questions. What matters more, the individual or the group? Is authority derived from the citizen or the state? Is a promise a personal commitment or a spiritual one? By comparing these systems, we see that our modern legal landscape is a tapestry woven from these ancient threads. And perhaps most beautifully, this global comparison shows us something else, that humanity, in its scattered corners of the world, independently and repeatedly arrived at the same brilliant solution to the problem of trust. We may have decorated the solution with our own cultural designs, but the core invention, the binding power of a written promise, stands as a universal testament to human intelligence and our shared need to build a world we can count on. Yet for all the remarkable stability and trust they built, these ancient contracts also cast a long and often dark shadow, revealing a troubling truth about the nature of law itself. The very same tools that enabled cooperation and commerce could also be masterfully wielded as instruments of profound exploitation, meticulously codifying inequality and binding the vulnerable in chains that were all the more powerful for being perfectly legal. This is the central ethical dilemma at the heart of contract law, a tension that was present at its very inception and continues to resonate uncomfortably in our own time. The contract was never a neutral technology. It was a reflection of the society that created it, and in the ancient world, that society was built on a foundation of stark power imbalances. Those who held the power, the wealthy landowners, the temple elites, the royal officials, were also the ones who dictated the terms, drafting the rules of the game to consistently favor their own interests. We see this most starkly in the grim reality of debt slavery, a system where a simple loan agreement could become a life sentence of servitude. The contract itself was the trap, its terms often deliberately designed to be inescapable. A desperate farmer borrowing seed grain to feed his family after a poor harvest would agree to interest rates as high as 33%, a figure that made repayment a mathematical impossibility. The contract would then coolly stipulate that he, his wife, and his children would enter the creditor's household as bonded laborers until the debt was paid. But with the accruing interest and the meager rations provided as sustenance, that debt would only balloon, effectively condemning entire families to generational servitude. While rulers like Hammurabi paid lip service to limiting such practices with laws capping service to 3 years, the archaeological record shows a different story. Creditors found simple ways to circumvent the spirit of the law, perhaps by drawing up a new loan contract at the end of the term or charging for the cost of those basic rations, perpetually resetting the clock on the debt. The contract, in these cases, was not an instrument of mutual benefit but a weapon of economic violence, using the full force of the law to create a permanent underclass and concentrate wealth in the hands of the few. This dynamic of exploitation extended far beyond individual loans into the realm of international relations, where so-called unequal treaties were used to impose the will of powerful empires on weaker neighbors or conquered peoples. The victor would dictate the terms, forcing the defeated party to sign a contract that legally obligated them to pay crippling annual tributes of gold, grain, and manpower. These were not negotiations, they were diktats presented as formal agreements but undergirded by the implicit threat of renewed military action. The famous Treaty of Kadesh between the Egyptians and Hittites is often celebrated as an early example of international diplomacy, and indeed it established peace. But it was a peace built on a carefully negotiated balance of power between two superpowers. For smaller states caught in the middle, the treaties were far less equitable, legally binding them to a status of vassalage and stripping them of their autonomy under the solemn guise of a signed document. The law was thus used to legitimize and perpetuate the spoils of war, transforming raw conquest into an ongoing, legally enforceable entitlement. Furthermore, these ancient legal systems systematically encoded gender disparities into their very fabric. While we've seen that marriage contracts could offer women some financial protections, their broader legal capacity was severely limited. In many societies, a woman was considered a perpetual legal minor, requiring the authorization of a male guardian, her father, husband, or son, to engage in any significant contract, whether it was selling property, taking out a loan, or initiating litigation. Her consent was often a legal formality. The laws themselves valued women less. The penalty for harming a free-born woman was typically far lower than for harming a man of the same status. This wasn't an oversight. It was a deliberate design feature of patriarchal societies that used the law to control female autonomy, ensure the legitimacy of heirs, and keep property firmly within male-controlled bloodlines. The contract became the mechanism for transferring a woman from the authority of her father to that of her husband, treating her as a key piece of property in the economic alliance between two families rather than as a fully independent legal person. This ancient ethical dilemma is startlingly relevant today. We may have abolished outright debt slavery, but we grapple with modern equivalents in the form of predatory payday loans, student debt that can never be discharged, and non-negotiable adhesion contracts, those dense walls of fine print we all blindly accept when we click "I agree" on a website or sign a cell phone contract. The power imbalance and information asymmetry between a massive corporation and an individual consumer is not so different from that between a Mesopotamian temple and a starving farmer. The modern tools might be digital, but the core dynamic remains. Those who draft the terms hold all the power, and the law often struggles to police the line between a hard bargain and an exploitative one. This forces us to ask a fundamental question that has haunted contract law since its birth on those clay tablets. What is the ultimate purpose of a contract? Is it merely to maximize efficiency, to enforce whatever two parties have agreed to, regardless of the fairness of the terms? Or does the law have a higher duty to also ensure equity, to step in and void agreements that are profoundly unconscionable, that exploit desperation, or that reinforce oppressive power structures? The ancients, for all their harshness, occasionally recognized this duty with acts of debt forgiveness. Our modern legal systems have tools like the doctrine of unconscionability to address it. The enduring lesson from these ancient examples is that law is never a neutral referee. It is always and inevitably a mirror, reflecting the values, biases, and power structures of the society that creates it. A contract can be a tool for building trust and enabling amazing human achievement, but in the wrong hands, it can just as easily be a weapon, dressed in the respectable clothing of legality. From the humble beginnings of a wet clay tablet inscribed with a promise to the complex digital agreements we click without a second thought today, the journey of the contract is nothing less than the story of civilization itself. It is the invisible architecture of human cooperation, the framework that allowed us to move from isolated family groups to interconnected global networks of millions. What these ancient systems teach us, with their meticulous seals and solemn oaths to the gods, is that law was never just a list of rules carved in stone. At its heart, it has always been about something far more fundamental: the delicate, essential art of building trust between strangers. It was a technology for communication, a way to translate a handshake into something durable, to transform a personal vow into a community guarantee that could outlive the individuals who made it. This was the true innovation, not the writing itself, but the creation of a shared reality where a promise could be believed. As we navigate our own complex legal landscapes, filled with terms of service and end-user license agreements. The echoes of these ancient practices are everywhere. They remind us that the core principles we still strive for: fairness in our dealings, clarity in our communications, and accountability for our actions, are not modern inventions. They are timeless human needs, the very bedrock upon which any functioning society must be built. The next time you sign your name on a dotted line or click, "I agree," remember that you are participating in a tradition that is thousands of years old, a continuous human experiment in creating order from chaos through the power of a promise made and kept. If you found this journey into the origins of our legal world as fascinating as we did, we'd love to hear your thoughts down in the comments. What aspect of these ancient contracts surprised you the most? And for more deep dives into the hidden frameworks that shaped our history, be sure to subscribe.